I think, as you know well, Tom, a particular academic interest of mine has been to explore the principles of equity and how they apply to professional claims.
Yeah, I remember that when the first edition of your book came out soon after Target Holdings, in which, of course, you acted, Tom, for the bank. And in that case, as readers will know, the House of Lords held that breach of trust remedies apply to the misuse of client funds.
Yeah, that's right. In fact, William and I decided to write the first edition of this book together after we'd both been in the nationwide litigation in the late 90s, a long time ago now, which explored claims of breach of trust and breach of fiduciary duty.
Tom, what particular developments have you witnessed since then?
Well, I think the most challenging area I find most recently is limitation in equity. So Section 21 of the Limitation Act, 1980, provides that there's no limitation period for a fraudulent breach of trust or the recovery of trust property. And one particular difficulty which the courts have had over the intervening years is to decide whether this provision applies to all sorts of trusts or only some trusts. So, for example, it clearly applies to the trust of monies held by a solicitor in a client account, which is released without the client's authority. And that's the classic Target situation, if you remember. The solicitor is dishonest or the claim to recover the funds is released, and then there is no limitation period for any claim under Section 21. And in Chapter 4, we also expressed the view that Section 21 applies to the kind of quis type trusts or resulting trusts, where the solicitor holds money not for the client, but for a third party. Again, a modern example of that kind of trust is where the solicitor gets involved in a high-risk investment scheme. And those schemes have become very popular, and the promoters often use a solicitor to lend colour or respectability to the scheme. So they ask investors to pay money into a solicitor's client account, and this gives comfort to the investors that the scheme is honest and safe. Claims against the solicitor for the return of the money, the view we expressed is that Section 21 applies. This can be a crucial issue where if you have a Ponzi scheme, the investor receives a few of the promised payments, but only discovers years later that the solicitor released the money in breach of the trust or undertaking.
Tom, how does limitation apply to claims against solicitors for dishonest assistance or some form of accessory liability?
Well, that's a very difficult question. It's now pretty well settled that Section 21 only applies to what we now call Category 1 constructive trusts rather than Category 2 constructive trusts. And what are these two categories? Well, the distinction between them was first made in the 19th century cases, but Lord Millett, in his archaeology of equity, has been the champion of this distinction in the modern cases. So Category 1 cases are analogous to real trusts. Most obvious example is where the solicitor is not actually formally appointed as a trustee, but acts as if he were one. And the facts of the very famous case in Phipps and Boardman provide a classic example of that kind of Category 1 trust. Category 2 trusts are where the court grants an equitable remedy. Solicitor isn't a trustee or doesn't act like one, but he gets involved in wrongdoing by a trustee or a fiduciary. And in Williams and Central Bank of Nigeria, the Supreme Court has recently held that Section 21(1) doesn't apply to dishonest assistance or knowing receipt claims. In those cases, a 6-year time limit applies, as it does to what I would call a non-custodial breach of fiduciary duty, non-disclosure or conscious wrongdoing. But there are a number of anomalies which are very difficult to explain and even more difficult to justify. And if I could just give you a few examples. First, in Williams, the Supreme Court accepted that although Section 21(1) doesn't apply to dishonest assistance or knowing receipt, Section 21(3) does. And there's no rhyme or reason for that distinction. It's simply the wording of a section carried through from the Limitation Act passed 50 years before. Secondly, it looks as if the time limit for dishonest assistance can be extended under Section 32 for fraud, 32(1)(a) that is, but not for knowing or ministerial receipt, which is often another category of claim, and often the two claims arise on the same facts. And again, the reason for this anomaly is simply that dishonesty is not a core ingredient of the cause of action. It's got to be knowing or unconscionable receipt, but not actual dishonesty. And thirdly, the time limit for both dishonest assistance and knowing receipt can be extended under section 32(1)(b) for deliberate concealment. So you have a curious situation that the time limit can be extended for dishonest assistance, for fraud or deliberate concealment, but not for knowing receipt, where it can only be extended for deliberate concealment. And fourthly, there's no clear statement in any of the cases about when time starts to run. And in the recent edition, I suggest that it should run from the date of the breach or the assistance or receipt, whichever is the later, but it's very hard to find a modern authority for that proposition.
Thanks, Tom. I think you've given a pretty clear flavour of the complexities of this area of the law. I'm just wondering if there's a case for some sort of reform here.
Well, that's an interesting question. And in my view, there is a real case for reform. I think the research which I've done into this area has persuaded me that it's a very strong case for ironing out the anomalies and uncertainties created by Section 21, which I've described very briefly. I mean, they seem to me to have generated a great deal of unnecessary litigation. But this isn't the time for a detailed discussion of law reform in this area. But in my view, a single time limit, possibly 3 years, based on the date of knowledge for both equitable and common law claims against solicitors, would be the way to go.